Sedition Act, which are the main provisions of the Act which permit the police to arrest and prosecute and for the courts to jail people for exercising freedom of speech and for the media to express views and political views. The judge held that those provisions are inconsistent with a sovereign democratic state, which is guaranteed in Section 1 of the Constitution. Section 1 of the Republican Constitution imposed an obligation upon the state to ensure that Trinidad and Tobago is a sovereign democratic state. And therefore he held that the sedition laws which were introduced in the United Kingdom when there were kings and queens and which were instituted to prevent criticisms of the king and the queen are not relevant to a sovereign democratic state, because since 1976 the sovereignty of Trinidad and Tobago is not in the king or the queen, it's in the people. In other words, the government is the servant of the people and not the people the servant of the government. So it is in that context, sovereignty of Trinidad and Tobago resides with the people of Trinidad and Tobago, and it would therefore be inconsistent if the people criticize the government, although they have the right to choose a government. It will be inconsistent with the Constitution and with democracy if the people criticize or the press criticize the government, to say that that can defame the government to result in a criminal charge and for people to be jailed for it. So that was the rationale of the decision. It violates the rule of law, it violates democracy, and it violates the principles of certainty. The law is vague, the law is uncertain, and the law cannot be upheld. As you would notice, the judge refused to grant a stay of execution of the declaration, and because in addition to his ruling, we objected to it because the court, as from today, has declared the provisions, those impugned provisions of the Sedition Act, unconstitutional. If there is an appeal and there's an application by the Attorney General to state, then we would show to the Court of Appeal that the appeal is not likely to succeed. It will be a frivolous appeal, and the Court of Appeal would have a duty not to grant any stay or suspend the order. What should happen now is both the Attorney General and the Office of the DPP should ensure that all prosecutions which were instituted under this Act was stayed to abide the decision of either the Court of Appeal or the Judicial Committee of the Privy Council. We are prepared to fight this battle to the end, to defend the right to the freedom of speech and to defend democracy. What this case also highlights is the importance of the judiciary as the guardian of the right of the people. When we got independence and when we became a republican state, the Constitution gave to the courts the importance and the duty to protect the rights of the people. So the court is given the power, omnipotent power, to declare any act of the state, whether it's an act of the executive, whether it's an act of the legislative, or whether it's an act of the judiciary, unconstitutional, null and void and of no effect. And that is why it is important for the judiciary to maintain the confidence of the people and for the judiciary to be competent in order to guard the rights of the people. And that is why the judiciary as an institution must be protected and safeguarded. And if there are any failings at any time, whether in appointment or in elevation, the people should cry out and call for a judiciary to be strong, independent, and fearless. The second issue that this case raises is the importance of lawyers taking steps to protect the rights of the people. And I want to publicly congratulate Fortis Chambers and Mr. Jagdeep Singh, because those chambers conceptualized the case. They are the ones who conceptualized it. I assisted in presenting it. So I think they should be congratulated today. And I do not know why Mr. Jagdeep Singh is not given sit, because he has done everything that many SILs haven't done in Trinidad and Tobago.
Agreed.
Right? This case also highlights the importance of individuals, citizens in Trinidad and Tobago, challenging the state when they do things. So Mr. Satmaraj, dead and gone, he should be congratulated for taking action, because today he would leave a legacy for all of Trinidad and Tobago, and not only for Trinidad and Tobago, for the Commonwealth, because these sedition laws are the same laws that they have in the Commonwealth. These are the sedition laws in which not only the people in Trinidad and Tobago that the judge referred to, Mahatma Gandhi was prosecuted and jailed for freedom of speech against the British rule in India. So I want to congratulate, although he's dead and gone, Mr. Satmaraj, his memory, and I want to congratulate his executors and those who are carrying on this battle. I also want to congratulate the media for taking an interest in this battle.
Thank you. Mr. Maharaj, I don't know if you want to say a few words